I would like to note that today the following judges are present with me in the Great Hall of Justice: Vice President Gevorgyan and Judges Tomka, Abraham, Yusuf, Sebutinde, Iwasawa, Nolta, and Charlesworth, and Judges Ad hoc, Pillay, and Kress, while Judges Benuna, Shway, Bandari, Robinson, and Salam are participating by video link. The Court meets today to hear the first round of oral argument of the Gambia. I shall now give the floor to the agent of the Gambia, His Excellency Mr. Dawda Jallow. You have the floor, Your Excellency.
Madam President, honorable judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. Over 2 years ago, the Gambia filed its application with this court, exercising its right as a party to the Genocide Convention to hold Myanmar to account for its ruthless acts of genocide against the Rohingya group in Myanmar. My esteemed predecessor said that he stood before you then, as I do now, to awaken the conscience of the world and to arouse the voice of the international community. The court rose to that challenge and unanimously ordered provisional measures against Myanmar that have, to this very day, helped to protect the Rohingya group from a repeat of the violent acts of genocide that Myanmar's military, the Tatmadaw, had inflicted upon them. We must never forget the Tatmadaw's mass murder, its coordinated use of rape and sexual violence as a weapon of genocide, its burning of villages with people locked in their homes, its targeted killing of children and the elderly, its murder of people as they fled these so-called clearance operations, and its order to kill all that its soldiers could hear and see. Justice and accountability for those acts of genocide and for Myanmar's ongoing acts of genocide is not just possible, it is necessary. A solemn obligation shared by the Gambia, every state party to the Genocide Convention, and the international community as a whole. It is why the international community drafted and adopted the 1948 Genocide Convention. It is why the Gambia filed its application against Myanmar over 2 years ago. It is why the United Nations, the organizations of the Islamic Cooperation, and the states around the world have welcomed and supported the Gambia's case. And it is why the Netherlands and Canada have publicly announced their intention to intervene under Article 63 of the court statute. It is why this court must reject Myanmar's meritless preliminary objections and proceed to adjudicate the merits of this dispute. Madam President, honorable judges, the Gambia may be a geographically small state, but we stand tall in the international community of states and take pride in promoting and protecting human rights and international accountability for atrocity crimes like genocide. We work bilaterally with other states and through multilateral institutions in our sovereign capacity for these and other national goals. It is a statement to the Gambia's diplomacy. It is a testament to the Gambia's diplomacy that the 57 member states of the OIC formally endorsed and supported our action before this court, not to mention the many others who have subsequently done the same. We are no one's proxy. As my predecessor told you at the outset of this case, this is very much a dispute between the Gambia and Myanmar. We seek to protect not only the rights of the Rohingya, but our own rights as a state party to the Genocide Convention by holding Myanmar to its acknowledgement party's obligation and not to commit genocide, not to incite genocide, and to prevent and punish genocide. These violations of the Genocide Convention are a stain on our collective conscience, and it would be irresponsible to pretend that it is not our business. We make it our business when we, as civilized nations, committed ourselves to the pact under the 1948 Genocide Convention. At the last oral hearings, Myanmar raised the very same objections that are before the court now. The court rightly rejected them in its order of provisional measures. Nothing has changed that would warrant the court to depart from its previous unanimous decision, and we call on the court to swiftly reaffirm its previous rejection of these groundless objections. Now, even more than before, justice within Myanmar is impossible. And now, as before, only this court can hold Myanmar to account for its acts of genocide. Madam President, honorable judges, justice delayed is indeed justice denied. The Rohingya and all people of Myanmar deserve justice and accountability. The Gambia is grateful that the court has settled these hearings so that this case may proceed without further delay. As a state party to the Genocide Convention, the Gambia fully expects that the court will uphold its right to have this case heard on the merits. The Gambia urges the court to proceed as expeditiously as your careful deliberations allow. The Rohingya deserve no less. The Gambia is proud to be represented by a diverse team of international advocates who will address all of Myanmar's preliminary objections in turn. Mr. Paul Raidla will speak first to update the court on the developments in this dispute since 2019. Mr. Andrew Lowenstein will then demonstrate what should be the obvious point, that the Gambia is the applicant state and not acting as a proxy for any other entity. Professor Per Dejean will establish the Gambia standing to bring this case as a state party to the Genocide Convention. Next, Ms. Tafazwa will show that Myanmar's reservation to Article 8 does not deprive the court of its jurisdiction, which is explicitly provided for under Article 9 of the Convention. Mr. Asalan Suleiman will confirm that a dispute existed between the Gambia and Myanmar over its violations of the Genocide Convention as of the time the application in this case was filed. And finally, Professor Philip Sands will provide concluding remarks for the Gambia's first round of arguments. Madam President, honorable judges, it remains for me to thank you for your courtesy, for your keen attention to this case, and for allowing me to address you. With your permission, I would ask that you called upon Mr. Raidla to address you virtually. Thank you very much.
I thank the agent of the Gambia for his statement, and I now invite Mr. Paul Reichler to take the floor. You have the floor, Mr. Reichler.
Madam President, members of the court, good afternoon. It is, as always, an honor for me to appear before you. It is a special privilege to do so in this case on behalf of the Gambia and to speak in support of its efforts to protect the Rohingya people in Myanmar from destruction as a group by the respondent state, and to prevent further state-initiated acts of genocide against them by holding Myanmar accountable under the Convention on the Prevention and Punishment of the Crime of Genocide. Madam President, a lot has happened since the parties last appeared in this court in December 2019. Two major events stand out above the rest. First, in January 2020, the court indicated provisional measures. Second, 1 year later, in February 2021, Myanmar's armed forces, the Tatmadaw, overthrew the elected civilian government. They then filled top governmental positions, including Prime Minister and Deputy Prime Minister, with the same senior army generals whom United Nations bodies have accused of responsibility for the acts of genocide that, according to their findings, were committed against the Rohingya people between 2016 and 2018. These two overarching events and their consequences set the context in which these hearings on Myanmar's preliminary objections are taking place. My remarks today will be addressed to them and the implications they have for the remainder of the proceedings in this case, including Myanmar's effort by means of its preliminary objections to escape the court's jurisdiction. Madam President, there is good news and bad. The good news is that the provisional measures indicated by the court in January 2020 are having an effect. To be sure, they are not as effective as they might be, and in no sense is Myanmar fully complying with them, as the Gambia has made clear in its observations on Myanmar's periodic reports. But the court's measures have helped to prevent the worst from happening. In particular, there has been no resumption of the clearance operations that the Tatmadaw carried out against the Rohingya population with such devastating brutality and effect in prior years. There have been no new mass killings of Rohingya, no new mass rapes or gang rapes of Rohingya women and girls, and no new burning of populated Rohingya homes and villages with families locked inside. The Gambia attributes the absence of such overtly genocidal acts to the existence of the court's provisional measures and its ongoing exercise of jurisdiction and oversight. Myanmar's military junta has been impervious to pleas of restraint from around the world, including from members of the United Nations Security Council, other UN bodies and agencies, and neighboring states. None appear to have had any influence on its behavior, except for the court. Even after the coup of 1 February 2021, the military government has continued to submit reports on its alleged compliance with the court's provisional measures order. It has appointed a new agent. It has retained new counsel. And it has appeared at these hearings to plead its case on preliminary objections. Plainly, by its actions, it has shown that as a party to these proceedings, it will not or dares not disregard the court. In these circumstances, maintaining the existing provisional measures in effect is essential for the protection and survival of the estimated 600,000 Rohingya who remain in Myanmar today. The court's measures are the last and only remaining constraint on the military government's policies and practices toward this extremely vulnerable and existentially threatened group. Even under elected civilian rule, prior to February 2021, the Tatmadaw was a law unto itself, especially in regard to its treatment of the Rohingya. As Myanmar's then agent, who is now imprisoned and incommunicado, explained in December 2019, quote, under its 2008 constitution, Myanmar has a military justice system. Criminal cases against soldiers or officers for possible war crimes committed in Rakhine must be investigated and prosecuted by that system, end of quote. If there was no accountability in Myanmar for acts of genocide committed by military personnel then, there is certainly none now. This is because the individual authors and perpetrators of the genocide against the Rohingya, the very same military leaders most responsible for planning it and carrying it out, are now openly in charge of the government. Any restraints on their behavior that an elected civilian government or the image of democratic legitimacy might have provided have been cast aside. The Tatmadaw now exercise all state power nakedly and directly, and that is the bad news. And it is still worse. The devils are in the details. The main architect of the military coup, Senior General Min Aung Hlaing, was the principal architect of the Rohingya genocide, according to the United Nations fact-finding mission, whose 2018 and 2019 reports formed part of the factual basis for the Gambia's provisional measures request. After the coup, Senior General Hlaing appointed himself Prime Minister. Serving immediately under him as Deputy Prime Minister is Vice Senior General So Win. The UN fact-finding mission found him responsible as Commander-in-Chief of the Tatmadaw for directing the clearance operations against the Rohingya, including the deployment of combat divisions to Rakhine State for the purpose of eradicating them. Other Tatmadaw officers and head key government ministries and agencies. This includes the acting president, Lieutenant General Myint Swe. As chair of the Investigation Commission for Maung Daw, he found that there were absolutely no cases of genocide or religious persecution in the region. This demonstrated, in the views of the UN Special Rapporteur on the situation of human rights in Myanmar and the Special Advisor on the Prevention of Genocide, a complete lack of independence. Not surprisingly, despite a plethora of so-called investigation commissions, as described in the Gambia's memorial, no one, not a single military officer or enlisted person, has ever been accused, let alone convicted, of genocide, either under the military regime or during the prior civilian government. Madam President, there is presently no national or international body or institution of any kind to which Myanmar's current leaders have acknowledged accountability in any way, except as they continue to demonstrate for this court. That explains why they persist in pursuing their preliminary objections, the very same ones that the court already rejected on a prima facie basis in its order of January 2020. If they can escape the court's jurisdiction, they will be accountable to no one, and there will be no constraints on their persecution and ultimate destruction of the Rohingya. The evidence gathered by United Nations bodies since the February 2021 military takeover demonstrates that this is still the Tatmadaw's objective. According to the UN Special Rapporteur, in a report dated 2 September 2021, at tab 2 of our judges' folders, the estimated 600,000 largely stateless Rohingya in Rakhine State continue to face existential threats and remain discriminated against in accessing citizenship, freedom of movement, and other fundamental rights. Since the coup, the junta has demonstrated that it intends to ensure that the Rohingya remain disenfranchised and segregated. In particular, the Special Rapporteur stated, also at tab 2 of our folders, as are the rest of the materials I will be displaying, since the coup, the junta has continued to deny the existence of the Rohingya while keeping them disenfranchised through their unresolved legal status, institutional discrimination, human rights abuses, restrictions on their movement, and limited access to livelihoods and essential services. Among other forms of discriminatory treatment that threaten to destroy the Rohingya as a group, the junta, quote, the junta continues to force or coerce Rohingya to accept the National Verification Card, NVC. The NVC process, the NVC process continues to require Rohingya to self-identify as foreigners, and as such, remains an administrative tool to erase Rohingya ethnic identity. In an official public statement issued last month, on 7 January 2022, Myanmar's Ministry of Foreign Affairs criticized the International Organization for Migration for its use of the term Rohingya. Myanmar steadfastly rejects the term Rohingya, which has never existed in legal and historical records of the country, and the people of Myanmar do not recognize it. The military government continues to block citizenship for Rohingya in innumerable ways and to deny them the fundamental rights that only citizens can enjoy, including those rights regarding birth and marriage. Rohingya people continue to face discriminatory laws and policies blocking their access to citizenship, documentation, and civil registration, despite legislative commitments to universal birth registration. Under the 2019 Child Rights Law, the birth of Rohingya children continue to not be systematically registered. Updating civil registration records, including birth and marriages, through the household list remains a challenge, negatively affecting access to legal documentation, basic services, and freedom of movement. The statelessness, internment, and movement restrictions maintained by the junta deny the Rohingya access to the basic necessities of life and leave them especially vulnerable to destruction by the state. There are an estimated 130,000 stateless Rohingya who remain confined in internment camps in Rakhine State, and those in villages throughout the state face increased movement restrictions and are continually impeded from accessing citizenship, services, and livelihoods. As a result, the Rohingya remain at grave risk of mass atrocity crimes. As a result, the Rohingya remain at grave risk of mass atrocity crimes. Madam President, the Special Rapporteur here recalls what human experience has long taught us, that it is just a short step from dehumanizing a people to killing them en masse. In the words of Simone Weil, on the eve of the Holocaust that would soon unfold, quote, once a certain class of people has been placed by the temporal and spiritual authorities outside the ranks of those whose life has value, then nothing comes more naturally to men than murder. The Tatmadaw have shown, both historically and since they have assumed direct power in Myanmar, that Rohingya lives have no value to them. This is especially true of Rohingya women and girls, who continue to be victims of singularly destructive policies and practices. The UN Special Rapporteur, in his latest report, called particular attention to the, quote, detention and forced labor among women and girls living in internment camps. And he cited reports that, quote, Rohingya women and girls are trafficked regularly from internment camps in Rakhine State. The Gambia quoted extensively from the Special Rapporteur's latest report in its observations on Myanmar's fourth compliance report filed with the court on 7 December. It calls out here in these proceedings before the one institution to which the Myanmar authorities purport to remain accountable, Myanmar's ongoing policies and practices that threaten the survival of the Rohingya people. The Gambia does so in hopes that, out of respect for the court, those authorities will feel compelled to untighten the noose they have placed around the Rohingyas' necks. 2 days ago, in these proceedings, the agent from Myanmar extolled his government's approach to the repatriation of hundreds of thousands of Rohingya refugees who fled the country during the clearance operations to avoid destruction at the Tatmadaws' hands. Here is what the Special Rapporteur said about this subject just 2 months ago in a statement issued on 19 December 2021. The relentless assault by the Myanmar military junta's attacks on its own people, as well as the systematic land clearance in Rakhine State, and the ongoing system of discrimination against the Rohingya in law and practice continue at this time. This means that the conditions for the safe, sustainable, dignified return of the Rohingya to their homeland currently do not exist. It will take considerable time and significant effort to create such conditions in Myanmar. Madam President, my colleagues who follow me today will demonstrate one by one why each of Myanmar's 4 preliminary objections has no merit whatsoever. The court was correct in rejecting them on a prima facie basis 2 years ago, and Myanmar has failed to make them any more meritorious in the time since then. Not in its written pleading of 20 January 2021, and certainly not in its oral presentations on 21 February 2022. Notwithstanding their lack of substance, Myanmar has already benefited from filing them. It has stopped the clock on the merits phase of the case for over a year since the objections were filed in January 2021. In so doing, it managed to obtain a lengthy delay in the filing of its counter-memorial, which may not be due until sometime next year. Meanwhile, the agony of the Rohingya is extended further. Human Rights Watch, in its latest report on Myanmar, issued on 7 December 2021, had this to say about the delay in these proceedings. Quote, "The court will next hold hearings on the preliminary objections Myanmar filed 10 days before the coup. There is no quick route to justice in Myanmar, but never has the call for it been louder. The Gambia trusts that the court will hear this call for justice again, just as it did at the provisional measures phase. In the circumstances, we hope for a prompt judgment from the court. We have no doubt that the judgment will be based on the facts and the law, and that it will be rendered in an objective and impartial manner. We pray that the case will then move forward as expeditiously as possible through the merits phase to its just conclusion. Madam President, members of the court, I thank you for your kind courtesy and patient attention, and I ask that you call upon my colleague, Mr. Andrew Lowenstein, to address Myanmar's first preliminary objection.
I thank Mr. Reichler, and I now invite Mr. Andrew Lowenstein to address the court. You have the floor.
Madam President, members of the court, good afternoon. It is an honor to appear before you and to do so on behalf of the Gambia. I will address Myanmar's first preliminary objection. This objection, in effect, asks the court to erase the Gambia's name from its application and to replace it with the Organization of Islamic Cooperation on the asserted ground that the OIC, and not the Gambia, is somehow the real applicant. On the basis of this substitution, Myanmar argues that the court lacks jurisdiction because only states and not international organizations may be parties to disputes before the court, or alternatively, that the application is inadmissible for the same reason. The objection lacks any basis in law or fact. I begin with the law. The relevant requirements for the court to exercise jurisdiction, ratione personae, are clear and straightforward. They are rooted in Article 92 of the UN Charter, which provides that the court shall function in accordance with the UN, with its statute. The pertinent provisions of the statute are located in Articles 34 and 35. Paragraph 1 of Article 34 provides that only states may be parties in cases before the court. Paragraph 1 of Article 35 then provides that the court shall be open to the states parties to the present statute. Tellingly, Myanmar did not mention Article 35 on Monday. That is perhaps not surprising. The provision is fatal to its argument. Article 35's use of unqualified mandatory language, shall be open, permits no exception to the requirement that the parties to the statute are entitled to have access to the court. Since Article 93, paragraph 1 of the Charter stipulates that all members of the United Nations are ipso facto parties to the statute, the Gambia, by virtue of its UN membership, is ipso facto a party to the statute as well. Accordingly, by operation of paragraph 1 of Article 35 of its statute, the court shall be open to the Gambia. Since both the Gambia and Myanmar are parties to the statute of the court, and also parties to the Genocide Convention, the Gambia is entitled to invoke the court's jurisdiction in accordance with Article 9 of the Genocide Convention. This, Madam President, should be the end of the matter. So how does Myanmar try to fashion its objection? As you heard on Monday, it advances the novel argument that the court can disregard the fact that the Gambia is the applicant and decide that some other entity is the real applicant. As you will have noticed, Myanmar could not cite a single instance in which this court, or its predecessor, or indeed any international court or tribunal, has ever suggested, let alone denied, that the applicant state is the real applicant. Nor, as far as the Gambia is aware, has any respondent state ever before asked an international court or tribunal to do so. Indeed, Myanmar could not even cite a single commentator, anyone, who supports this unprecedented theory. The reason is plain. Under Article 35, paragraph 1, states that are members of the United Nations are entitled to seize the court in accordance with an applicable basis for jurisdiction, such as Article 9 of the Genocide Convention. As Professor Rosen has observed, every state which is a party to the statute has the right to invoke the jurisdiction of the court in accordance with the general conditions for the exercise of that jurisdiction. It was precisely this right that the Gambia invoked when the Gambia commenced the present proceedings. Myanmar had nothing to say on Monday about Professor Rosen's commentary on jurisdiction. Myanmar, nonetheless, asks you to ignore the application and attempt to discern why, or on whose alleged behalf, the Gambia commenced these proceedings. Now, putting aside the fact that the Gambia brought the case because it has a dispute with Myanmar regarding its violations of the Genocide Convention, a matter to which I will return, the question of what motivated the Gambia to commence the case is wholly irrelevant as a matter of law. As the court held in paragraph 52 of its judgment on jurisdiction and admissibility in Nicaragua v. Honduras, the court cannot concern itself with the political motivation which may lead a state at a particular time or in particular circumstances to choose judicial settlement. The court's case law has thus been clear that it does not matter whether the Gambia's motivation for bringing the case was its outrage over Myanmar's genocidal acts, the urging of other members of the international community, a proposal by the OIC, or any other reason. As the court held, none of this has any relevance for the exercise of its jurisdiction. There is good reason for this. As Professor Tamushat has observed, the court's holding that any possible political motivation of an application is irrelevant for the discharge of its judicial function would seem to be the court's final word on the issue. That is because, Professor Tamushat further observed, the court would emasculate itself if it refrained from agreeing to clarify the legal position in disputes of great importance for peace and security. Myanmar did not address Professor Tamushat's commentary either. So, how does Myanmar make its argument? On Monday, while conceding that the applicant's motivation is irrelevant to the exercise of jurisdiction, Myanmar argued that its objection is not based on the Gambia's motivation, but rather on whether the Gambia is the real applicant. This artificial formulation provides Myanmar no help at all. Myanmar's thesis for why the Gambia is not the real applicant depends on proving that the Gambia commenced the case at the OIC's behest, rather than for its own reasons. That is inevitably a question of motive, the very definition of which is a cause or reason that moves the will and induces action. As the court has ruled, such factors are irrelevant to the exercise of its jurisdiction or the admissibility of an application. Nor is Myanmar helped by arguing, as it also did on Monday, that whether the Gambia is the applicant is a question of substance that calls for objective determination. Even if that were correct, all the court would need to determine objectively is whether the Gambia is a party to the statute of the court. The UN Charter specifies how this is done. Parties to the Charter are ipso facto also parties to the statute. So, to the extent there is anything to be objectively determined, it is accomplished by verifying that the Gambia is in fact a member of the UN. As the Gambia indisputably meets that qualification, the requirements for jurisdiction ratione personae are satisfied. For the court to decide otherwise would be truly extraordinary. Turning now to the facts. The Gambia is, by any measure, the real applicant. On Monday, Myanmar tried to cast doubt on that reality by referencing an eclectic variety of websites, articles, tweets, and press releases. But Myanmar deliberately glided over the evidence that matters. And in making this argument, it was surprising to hear its counsel contend that the Gambia has said nothing about the events leading to the case. That is simply not true. So let's begin with what the Gambia has in fact said about the case. Madam President, the then agent and Attorney General of the Gambia, Mr. Abubakar Marie Tambadou, himself a former war crimes prosecutor at the International Criminal Tribunal for Rwanda, told the court why the Gambia brought the case and how it came about when he addressed you at the opening of the Provisional Measures hearing. He explained this in very direct terms. He recounted how he had visited the refugee camps in Bangladesh as part of an OIC delegation, and how, as he listened to the stories of the refugees, he could smell the stench of genocide from across the border in Myanmar. And he explained how he heard stories of helplessness in the face of mass killings, of mass rape and mass torture, and of children being burnt alive in the sanctuary of their homes and places of worship. The stories of these victims, the Gambia's agent told you, were all too familiar to me from a decade and a half of interaction with surviving victims of the Rwandan genocide. He further explained why the plight of the Rohingya had a particular resonance for the Gambia and why the Gambia was motivated to act. He told you 22 years of a brutal dictatorship in my own country has taught us that we must use our moral voice in condemnation of the oppression of others, wherever it occurs around the world, so that others will not suffer our pain and our fate. And so, the Gambia assumed a leadership role in mobilizing international action against the genocide of the Rohingya. The Gambia's efforts involved, among other things, working with the OIC and its member states to establish and then chair the OIC's ad hoc ministerial committee on accountability for human rights violations against the Rohingya. This does not in any way suggest, as Myanmar tries to argue, that the Gambia's actions, including those done in coordination with or through the OIC and or its ad hoc committee, are not the Gambia's own. Indeed, the Gambia's public statements regarding its efforts to promote accountability for Myanmar's crimes demonstrate that the Gambia itself was taking these actions, and that the Gambia was imploring the international organizations to which it belonged, including especially the UN and the OIC, to further that objective. For example, on the 25th of September 2018, that is over a year before filing the case, the President of the Gambia reported on these efforts to the UN General Assembly. He stated, "As the upcoming chair of the next OIC summit, the Gambia has undertaken, through a resolution, to champion an accountability mechanism that would ensure that perpetrators of the terrible crimes against the Rohingya Muslims are brought to book. As you can see, the President of the Gambia was apprising the General Assembly of the Gambia's use of the OIC to seek protection for the Rohingya and accountability for the perpetrators of the crimes committed against them. With respect to its interactions with both the UN and the OIC, the Gambia was acting in its own right and for its own purposes. Moreover, it was the Gambia itself that informed Myanmar by note verbal on the 11th of October 2019 that a dispute exists between the two states regarding Myanmar's violations of the Genocide Convention. You can find it at tab 3 of the Judges folder. The Gambia's note verbal is crystal clear that the Gambia is the party to that dispute. The Gambia stated, "The Republic of the Gambia is deeply troubled by the findings of the UN fact-finding mission regarding the ongoing genocide against the Rohingya people. This has been the case for more than a year, as the record indisputably shows." The Gambia's note verbal further stated that the Gambia considers those findings well supported by the evidence and highly credible, and is disturbed by Myanmar's absolute denial of those findings and a refusal to acknowledge and remedy its responsibility. The Gambia's note verbal also informed Myanmar that the Gambia insists that Myanmar take all necessary actions to comply with these obligations. There can be no confusing the Gambia with the OIC. The same note verbal distinguished between the two when it informed Myanmar that the Gambia fully endorsed a resolution of the OIC calling upon Myanmar to take measures to immediately halt all vestiges and manifestations of the practice of genocide against the Rohingya. Myanmar tries to argue that the Gambia acted on instructions from the OIC. The record shows otherwise. To begin with, it was the Gambia that conceived the idea of bringing a case against Myanmar under the Genocide Convention. As a sovereign state, the Gambia did not need anyone else's instructions or permission to pursue it. The fact that the Gambia sought and received the OIC's support and encouragement is both understandable and immaterial for purposes of this case. It is understandable because for a small state like the Gambia, gaining the political support of the 57 member states of the OIC manifestly increased the influence within the international community that could be brought to bear on Myanmar. It is immaterial because it has no bearing whatsoever on the identity of the applicant in these proceedings. It certainly does not make the OIC the applicant. As the court held in its provisional measures order, the fact that the Gambia may have sought and obtained the support of other states or international organizations in its endeavor to seize the court does not preclude the existence between the parties of a dispute relating to the Genocide Convention. As my colleague, Mr. Suleiman, will explain, there is undoubtedly such a dispute. Accordingly, independently of whether the OIC supported, encouraged, endorsed, proposed, requested, tasked, or whatever else may be Myanmar's preferred word to describe the OIC's relationship to the Gambia's decision to bring the case, the bottom line is this. The Gambia's decision to invoke the court's jurisdiction under Article 9 was the Gambia's decision, no one else's. That decision was undertaken at the highest levels of the Gambian government. In July 2019, a session of the Gambia's cabinet, presided over by His Excellency President Adama Barrow, discussed and approved the proposal for the Gambia's leading legal action against Myanmar at the International Court of Justice. In particular, the official statement of the Office of the Gambia's President records that the Attorney General and Minister of Justice presented a paper on the OIC proposal for the Gambia to lead the international legal action against Myanmar. The statement then memorializes that the Cabinet approved the proposal and also approved the Attorney General's appointment to represent the Gambia throughout the proceedings. To these facts, on Monday, Myanmar could only respond that when the Gambian Cabinet decided to bring the case, its announcement of this decision stated that the Gambia would lead the legal action. According to Myanmar, lead is insufficient to establish that the Gambia is the real applicant. So Myanmar's argument comes down to this. The court cannot exercise jurisdiction over a claim under the Genocide Convention because, in Myanmar's estimation, the cabinet of a sovereign state, when taking a sovereign decision for that state to initiate judicial proceedings, used the wrong verb. But even then, to lead the case is not to serve as anyone's puppet or proxy. The fact that the OIC has assisted in organizing political and financial support does not transform the OIC into the applicant or otherwise arrest the case away from the Gambia. The OIC itself has made clear that the case is not the organization's, but the Gambia's. The September 2019 report of the meeting of the OIC's ad hoc ministerial committee, when discussing the OIC's support for the Gambia, acknowledged the Gambia's prerogative to select a legal firm to pursue the case in the ICJ and took note of the Gambia's choice of the legal firm. On Monday, Myanmar asked, does this not suggest that this prerogative was conferred by the OIC? No, it does not. Here, it is Myanmar that uses the wrong verb. Conferred implies that something was given. Acknowledged, which is the word used by the ad hoc committee, constitutes affirmation of a fact or situation that already exists. In this case, it was the Gambia's prerogative as the applicant state to select its own counsel. The court need only consider another part of the same report, which Myanmar elected not to show you. This describes the litigation as the case undertaken by the Gambia. And to this I would add that counsel for the Gambia receive and accept instructions exclusively from the Gambia's agent, no one else. That has remained the case at all times, including in the preparation of the Gambia's application, its memorial, its written observations on Myanmar's preliminary objections, and all of the Gambia's observations on Myanmar's reports under the Provisional Measures Order. Madam President, nothing is changed by the fact that it has sometimes been said that the Gambia brought the case on behalf of the OIC, a description that does not describe a legal relationship, but reflects the fact that the Gambia enjoys the support of the OIC's 56 other member states, who, not surprisingly, are also outraged by Myanmar's crimes against their fellow Muslims. In its September 2019 report, the UN fact-finding mission, after concluding that Myanmar was responsible for genocide, welcomed the Gambia's efforts to pursue, in this court, a case against Myanmar under the Genocide Convention. It recommended that the UN and the international community encourage and support such a case. Does this mean that the Gambia brought the case on behalf of the United Nations, or that the UN or its fact-finding mission is the real applicant? Madam President, it could be said, and in fact is often said, that the Gambia brings this case on behalf of the Rohingya. In a sense, it did, because it brought the case to save their very existence. But just as this does not mean that the victims of Myanmar's genocide are the real applicants, neither do the references to the OIC or the UN negate the reality that the Gambia, in law and fact, is the applicant state. The court's jurisdiction, ratione personae, is therefore fully established. Madam President, I turn now to Myanmar's alternative argument that the court should decline to exercise jurisdiction on grounds of admissibility. Here, I can be brief. There are no grounds whatsoever for declining to exercise jurisdiction. There is no indispensable third party. The case does not concern a matter in which the Gambia lacks a legal interest. And, as Mr. Reichler showed, far from being moot or hypothetical, the case and the Provisional Measures Order continue to provide the Rohingya who remain in Myanmar with the court's protection at a time of acute vulnerability. Myanmar knows this, so it argues the case is an abusive process. An abusive process? Myanmar argued on Monday that this is because the Gambia has supposedly brought the case for aims alien to those for which the procedural rights have been granted. But Myanmar did not dare remind you of the actual aims of the procedural rights set out in Article 9. They are, of course, to allow states parties judicial recourse to prevent and punish the crime of genocide. Those are precisely the objectives of this case. This was recognized by the Secretary General of the United Nations, who welcomed the court's order on provisional measures. The Secretary General also cited the case as an example of the appropriate use of peaceful means for the settlement of international disputes. That view is shared by the UN General Assembly, which also welcomed the court's action. And it is shared as well by the Office of the UN High Commissioner for Human Rights, which described the proceedings before the court as being vitally important. Madam President, these facts lead to only one conclusion. The Gambia is the applicant. There is no basis to strip it of that role or to deny its right to bring this case as a sovereign state that is a party both to the statute of the court and the Genocide Convention. There is no merit whatsoever to Myanmar's first preliminary objection, and it must be rejected, as it was in the court's January 2020 order. Madam President, members of the court, this concludes my presentation. Thank you very much for your kind attention. I ask that you invite Professor Darjan to the podium to address Myanmar's second preliminary objection.
I thank Mr. Lowenstein, and I now invite Professor Pierre Darjan to address the court. You have the floor, Professor.
Thank you, Madam President. Madam President, members of the court, it is always an honor to speak before this court, and it is so again as I speak to support the Gambia. According to Myanmar's second preliminary objection, the Gambia's application is inadmissible due to the Gambia's lack of standing to take action in this case. Just like the other preliminary objections of Myanmar, this second objection had already been raised during the provisional measures stage. However, what is new since Monday's hearing is the reason given by Myanmar to support this objection. I would like to address this point in the first part of my pleading. I will then address the issue of common interest that characterizes the ergo omnes partes obligations and its significance with respect to the present case. In the third part of my presentation, I will come back to the question of standing to take action per se. And I will conclude in the fourth part by briefly examining Article 9 of the Convention, given what Myanmar has said about it in its written pleadings regarding the Gambia's standing to take action. Madam President, during the December 2019 hearings, Myanmar did not challenge the Gambia's right to invoke its international responsibility. This court's order of January 2020 states clearly, and I quote, Myanmar accepts that because of the erga omnes partes character of some obligations under the Convention, the Gambia has an interest in Myanmar's compliance with such obligations. End of quote. Myanmar thus accepted that the Gambia could indeed invoke its international responsibility. However, Myanmar challenged the Gambia's standing to take action before the court. That is to say, to bring this dispute arising from this invocation before the court. This is what has led to the rather absurd dead end according to which the dispute could indeed arise and exist following the invocation of Myanmar's responsibility, but it was not likely to be brought before the court for judgment. Whatever be the case, during the provisional measures stage and also in its written submissions supporting its preliminary objections, Myanmar argues that the Gambia did not have standing to take action before the court because Article 9 of the Convention excluded any actio popularis. As I mentioned at the outset, I will come back to this point at the end of my pleading. But since then, Myanmar has changed governments and councils and has modified its legal arguments. It now argues that the Gambia doesn't even have standing to invoke Myanmar's international responsibility. And why is that so? Because the Rohingyas, who are persecuted and killed by Myanmar, don't have Gambian citizenship. Yes, members of the court, you heard me right. Apparently, the Gambia cannot invoke Myanmar's responsibility and therefore would not have standing to bring the present dispute before the court because the victims of the clearance operations conducted by the Tatmadaw don't have Gambian nationality. If it weren't so tragic, I would be tempted to be ironical and remind Professor Talman that the Rohingya, that he obstinately refuses to call by their name, that the Rohingya did not have Burmese citizenship either, precisely because they had been stripped of their citizenship due to the law enacted in 1982. However, I would prefer to quote the exact words that he used on Monday. He said, and I quote, "The nationality of claims rule applies to the invocation of responsibility by both injured and non-injured states, and irrespective of whether the obligations breached is an erga omnes partes or erga omnes obligation. Under the law of state responsibility, the Gambia cannot invoke the responsibility of Myanmar for violations of the Genocide Convention with regard to individuals who are not its nationals. Madam President, it doesn't take much reflection to realize how absurd or even abject this legal theory is when applied to the Genocide Convention. If we were to follow Myanmar's reasoning, no state party to the Convention would have the right to invoke the responsibility of another state party as long as the latter meticulously implements its genocidal project exclusively on its own nationals. We all know, however, that genocide generally begins within a country, and that most often it targets the nationals of the genocidal state itself, a group that forms a certain ethnic, racial and religious group. Very often, as is the case with the Rohingya, the members of the group being targeted can be identified because they're deprived of the nationality of the country where they live and who persecutes them, whereas they're not the nationals of any other country. Can we seriously agree, members of the court, can we seriously agree that it is in conformity with the Convention's object and purpose to refuse in such a case that any other state has standing to invoke the responsibility of the state that is the perpetrator of genocidal violence? I would like to emphasize that the consequence of Professor Talman's theory would be not only to make it impossible to invoke the responsibility of the state committing genocide against the members of a group having its own nationality, but it would also protect a genocidal state from any similar invocation, even when this state targets members of a group having the nationality of one or several third state parties to the Convention. In that case, indeed, no state party would be able to take action either, unless the victims had the nationality of one of them. Madam President, members of the court, not only is the theory that Myanmar presented on Monday absurd, abject, and completely contrary to the object and purpose of the Convention, it is also erroneous with regard to the legal principles on which it is purportedly based. What does Article 44A of the Article on International Responsibility of States say? This is the article on which Myanmar has based its arguments. It says, and I quote, "The responsibility of a state may not be invoked if the claim is not brought in accordance with any applicable rule relating to the nationality of claims." End of quote. This provision does not give any indication that there might be a nationality of claims rule which would apply, broadly speaking, to any interstate claim. No, this is not what the provision says. This provision only recalls that when the rules in terms of nationality of claims apply, the invocation of responsibility of a state by another state is subject to these rules. When paraphrasing Article 44, the commentary of the International Law Commission, to which Professor Talman, in fact, referred, explains that the nationality of claims rule is a general condition for the invocation of responsibility in cases when it is applicable. The Gambia argues that in the case of the Genocide Convention, such a rule is obviously not applicable. Indeed, the nationality of claims rule is not applicable because nothing in the Convention's text suggests that it would be the case, particularly because, as I just explained, it would be contrary to the object and purpose of the Convention to make claims of state parties conditional on this rule. Need I remind the Court that according to Resolution 96-1, genocide is contrary to the spirit and aims of the United Nations, that it shocks the conscience of mankind by resulting in great losses to humanity through the total or partial destruction of a national, ethnic, racial, or religious group, regardless of the nationality or absence of nationality of the members of this group. What would happen to this essential and universal ratio legis that your order indicating provisional measures recalled if Myanmar's argument were to be accepted? Myanmar has made no reference to the object and purpose of the Convention when it argued that the nationality of claims rule was applicable to it. This silence is indeed eloquent, and Myanmar's about-face on the issue that it was purportedly impossible for the Gambia to invoke its international responsibility is not only misguided, but also baseless. In reality, and as Myanmar accepted in December 2019, but no longer seems to accept, it is indeed in the Gambia's interest that Myanmar fulfills its obligations, and this interest exists under Convention due to the erga omnes partes nature of its obligations. Madam President, members of the Court, Myanmar does not challenge the erga omnes partes nature of the obligation of the Convention, which is at the heart of the present dispute. Without going to the details of your jurisprudence, which is well established in this regard and that you recalled in your order of January 2020, Myanmar is nonetheless attempting to minimize its scope by arguing that a common interest, the existence of a common interest with respect to compliance with the Convention would not constitute an individual legal interest, to use Professor Talman's words, an individual legal interest intended to be enforceable before the Court, that the Court's jurisprudence, according to Myanmar, has never accepted this rule as such, and that in reality, according to Myanmar again, the Court has even cast a doubt on this rule in the Bosnia versus Serbia case. And yet, since the 1951 advisory opinion, this Court's jurisprudence tells us that in a convention such as the Genocide Convention, and I quote, "the contracting states do not have any interests of their own." End of quote. Myanmar is attempting to look for something in your jurisprudence that the Court has excluded over 70 years ago. When it concerns the Genocide Convention, there is no question of individual legal interest, and as the advisory opinion has already indicated, common interest of contracting parties belongs to one and all. However, this in no way implies that each state party would be deprived of an interest to comply with the Convention. Quite the opposite, actually. When a state party invokes the responsibility of another state that is bound by the Convention, it does indeed have an interest in doing so. However, its interest is not specific to the state itself. Its interest, which is shared by all other parties, is the interest in making sure that the common interest of prevention and repressing genocide is fully protected. As you have emphasized in your order of January 20, and I quote, that common interest implies that the obligations in question are owed by any state party to all the other state parties to the Convention. End of quote. That is to say, to one and all. The Court has inferred in paragraph 41 of its order, and I quote, that any state party to the Genocide Convention and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations erga omnes partes and to bring that failure to an end.
Now, Professor Tallman has somewhat challenged your ruling and has invited you to reconsider it. According to him, a careful rethink would be necessary because you won't have had the benefit of an adversary debate as the court gave its ruling at the provisional measures stage. Now, it's true that Professor Tallman was not the counsel of Myanmar at the time and that the arguments which he developed were not worded by or formed by Myanmar at the time. But I can restrict him, reassure him that the principle of an adversary hearing was guaranteed at all stages of the proceedings by the court, and indeed it was done so in December 2019. Indeed, it's erroneous to claim that paragraph 41 of your order only concerns the right of invoking responsibility and not standing. Indeed, this paragraph ends the second part of the order, whose title covers exactly the question of the standing of the Gambia. Professor Tallman adds that paragraph 41 of your order does not take into account the requirements of the rule about the nationality of claims, but I've already explained that this rule was not applicable to the claims between states party to the Genocide Convention. Paragraph 91 of the judgment in the Barcelona traction case, which was raised by Professor Tallman, also does not challenge this conclusion, because the court compares universal instruments for human rights concerning the denial of justice to the European Convention of Human Rights. So there is no mention, or it's not at all a question in this paragraph, of the Genocide Convention. Myanmar has further claimed that the judgment of Belgium versus Senegal would also be no assistance to the Gambia because the court did not need to examine in that case whether the nationality of claims limited the status of Belgium or the standing of Belgium to pursue the case. As an applicant state, Belgium had simply restricted itself to invoking the responsibility of Senegal to a breach of a repressive nature of its obligations. Nonetheless, this 2012 judgment did clearly underscore that as regards erga omnes partes obligations, if a special interest were required, then so as to be able to make a claim concerning the succession of an alleged breach by another state's party, then in a lot of cases no state would be in a position to make such a claim, full stop. So Myanmar is seeking precisely to obtain what the court tried to avoid by the 2012 judgment. Myanmar has also raised the question of the 2007 judgment in the Bosnia versus Serbia case to support its theory about the nationality of claims. But what did the court decide in that case? Well, that it didn't have to settle the question as to whether the nationality of claims limited the right of Bosnia to advance claims for acts inflicted on non-Bosnians outside its territory, lacking evidence to this respect. For the rest, the court simply said that insofar as that request might relate to non-Bosnians victims, it could raise questions about the legal interest or the standing of the applicant as regards such matters, and the significance of the jus cogens character of the relevant norms and the erga omnes character of the relevant obligations. What then should we note in this sentence? Well, that legal interest and standing are put on an equal footing, and that both necessarily depend on the erga omnes character of the obligations under the Convention and the peremptory nature of its norms. The Gambia does not say anything different, and the court reiterated or recalled in its 2020 judgment or order that the obligations of the Convention are indeed erga omnes partes. Madam President, distinguished members of the Court, the Gambia has indeed also has standing to invoke the responsibility of Myanmar and standing to bring this case before you. The Gambia has recognized that this last question is raised whenever the basis for jurisdiction is used, and the Gambia also accepts that it is a general exception, a demand to contentious cases before the court. Now, what actually is standing? Since the Wimbledon case, standing has been nothing else than the interest for the respect of the rules that are at the heart of a given dispute. In other words, the interest that a party has in a dispute to see this dispute settled according to the rules. If this interest exists, then standing is established. In the case of a bilateral obligation, standing derives from the practical and particular interest pursued by the legal action. But when the obligations which should be applied to solve the dispute are erga omnes partes, then it is the opposite that is true. It is then the identity of a party to the instrument bearing these obligations that establishes the act and the interest in acting. This is the same for all states to a party to a convention, because each have, to echo your words, a common interest in ensuring that their acts of genocide are prevented and that if they occur, their authors do not enjoy impunity. As the Court has already underscored, the specific nature of erga omnes partes obligations is due to the fact that each state party has an interest in compliance with them in any given case. Now, these words are opposed in any given case are opposed to those of in a specific case. Professor and later Judge Giorgio Gaia particularly stressed the specific nature of erga omnes obligations in his report to the Institut du Droit International. It is because it is the circumstances particular to each case do not have any bearing on the interest of any state in seeing these obligations respected that these obligations are of an erga omnes partes character. Consequently, any non-directly injured state also has a necessary interest to invoke the responsibility of a state accused of a breach of these obligations. When this invocation ends up in a dispute, as is in the case in the present proceedings, then Article 9 of the Convention opens the way for the Court to whichever of the parties to this dispute wishes to seize it. If the seizure of the court is by a non-injured party to the dispute, then its standing is due to its interest, which it has in common with other states parties to the Convention, to seeing it respected. It brings me to the last section of my pleadings, distinguished members of the bench. Madam President, distinguished members of the bench, Article 9 is a compromissory clause which is particularly clear and non-ambiguous. As your order of January 2020, as recalled, Article 9 governs two things. First of all, your jurisdiction and your seizing. Now, you know Article 9 rather well, and I shall not read it. I'll just project it on the screen as a reminder. Under Article 9, your jurisdiction extends to those disputes arising between parties to the Convention on the subject of obligations set out in that Convention without any prior procedural condition and without any limitation being binding upon the states parties to these disputes, if it's not for the fact that, of course, they have to be bound by the Convention. Of course, therefore, Article 9 indicates that such disputes can be submitted to the court for settlement by one of the parties to the dispute, and not by one of the parties to the Convention who is not a party to the dispute. As I've said, that's perfectly clear. Nonetheless, in his written submissions to support preliminary objections by Myanmar, Myanmar. Myanmar has claimed mainly that the Gambia lacks standing because Article 9 of the Convention is alleged to exclude any kind of actio popularis. In fact, under cover of an alleged lack of standing, Myanmar is in fact raising an objection of a lack of jurisdiction because it is advancing that Article 9 of the Convention will not allow the court to rule on a request submitted by a state party when the latter is not directly or personally injured by the actions that it is denouncing. According to Myanmar, the action popularis would therefore be materially excluded by Article 9 in such a way that the consent given to your jurisdiction by this article will not cover this kind of action. To support this theory, Myanmar, in its written submissions, concocts specious arguments concerning words lacking in Article 9 or differences between Article 8 and 9, whereas these provisions actually have completely different aims. A key point in the argument advanced by Myanmar, which I won't repeat in toto, is that Article 9 concerns not all disputes or any disputes, but just disputes. Now, you've heard virtually nothing on this subject on Monday, as Professor Kolb was the only one who vaguely referred to this argument when he contrasted Article 9 with Article 24 of the European Convention of Human Rights. Even if Myanmar has probably noted the weakness of its written arguments and has generally abandoned them on this point, I wish nonetheless to recall that Article 9 starts with the words disputes. Disputes in English, in plural, and in an undetermined and therefore inclusive manner. This provision requires disputes at issue between the parties do actually exist, and that they should be relating to the interpretation, application, or fulfillment of the present convention, which includes disputes, and I quote again, relating to the responsibility of a state for genocide or any other act enumerated in Article 3. So, in other words, it's enough for a dispute to exist, for a party to that dispute to bring it before the court, and for these providing, of course, that these two parties are both bound by Article 9. So the ordinary meaning of the words used in Article 9 leaves no doubt. No distinction is drawn between possible disputes as arising from the obligations of the Convention or between contracting states which are parties to these disputes, whether they are or not directly injured. The interpretation of Article 9 proposed by Myanmar is not only contrary to the ordinary meaning of the words which are used and to their context, but it also runs up again against the aim and purpose of the Convention. Despite the clarity of Article 9, Myanmar still asserts in its written pleadings that the tortuous interpretation that it proposes is allegedly confirmed by the travaux préparatoires of the Convention. Now, our written submissions have fully replied to the partial reading of the travaux developed by Myanmar, and I would remind you to refer to them, in particular as Myanmar has not said anything about it on Monday. But just so as to be exhaustive on Article 9, I will add that you have been seized by the Gambia of the dispute between it and Myanmar. This seizing is not due to another state which is bound by the Convention, which is not party to this dispute. The fundamental conditions, therefore, of Article 9 are all satisfied. Madam President, distinguished members of the Court, for the reasons that I've just expounded, and also for those developed and advanced in our written submissions, this second objectional preliminary opinion objection by Myanmar should be rejected. I would like to thank you for your kind attention and suggest that you would give the floor to Mrs. Paso Dia, perhaps after the break.
break of 10 minutes. The sitting is adjourned.